All right, good morning, everyone. Welcome to the Global Advertising Lawyers Alliance talk on non-fungible tokens, a global legal perspective. My name is Hannah Taylor. I'll be the moderator of this amazing panel today, and I'm joined by some of the wonderful gala members from around the world. And we are going to speak to you today about non-fungible tokens and how they sort of come together from a legal perspective when trying to create a global strategy for this new type of technology and marketing product. So it's very difficult to speak about non-fungible tokens without first setting the stage and discussing what is a blockchain. Now, there is a world in which a non-fungible token could exist off a blockchain, but most of the use cases that we've seen and the explosion of the popularity of this technology has really been blockchain based. So we thought it would help to ground the discussion in talking about what a blockchain is and how it is involved in the non-fungible token world. So a blockchain is basically just a database. It's a specific type of database that groups data into blocks and then chains those blocks together using cryptography. Now, obviously, we're not going to get into sort of the cryptographic details of how that exactly works, but it's important to understand that cryptography is involved as we get further into the discussion of non-fungible tokens. Now, a common misconception is that there is such thing as the blockchain. Actually, there are many blockchains. Many people have heard of the Bitcoin blockchain, the first most popular blockchain, and since then the creation of other blockchains like Ethereum, which we'll talk a bit more about, Tezos, Cardano, Flow, Solana, and each of them work differently. And so that's a very important thing to understand when counseling in this area, because if you don't understand the rules of the blockchain in which your project is going to be dropped on, it's very hard to counsel and come up with some of the major issues to watch out for. Now, the most common application of blockchain technology, at least in the NFT space, is to act as an electronic ledger. And that ledger gets stored, maintained, distributed, and replicated in a decentralized way. And what that means is that a lot of computers all across the world use peer-to-peer networking, and they all maintain this ledger, which means that if one of them does something, wrong, goes rogue, it allows for a more secure system, because that one computer doing something rogue can be sort of found out by all of the different nodes, which is what we call those computers that are maintaining this ledger throughout the world, and they have to all sort of agree on a certain transaction being added to the blockchain. So if one computer goes rogue, it won't be allowed to sort of cause any mischief. Now, these powerful computers all across the world in this network that are maintaining this ledger, which we said are called nodes, use what's called a consensus mechanism. So all that means is that in order for a block of data to be added to a particular blockchain, the nodes have to confirm and agree that that should be added. And that need for consensus removes the need for an intermediary like a Google or a Facebook or some other third party that checks the data or maintains the data, because all of the nodes are sort of checking each other. Now, once the nodes agree on the legitimacy of a block to be added to the blockchain, they agree that a list of transactions should be added to their blockchain, which means that there is consensus, then the block can be added to the blockchain. And that block gets cryptographically linked to the block before it, which is how it becomes a chain, and how it becomes very difficult to mess with one of the blocks or cause mischief, again, because even if you were to change, one of the computers were to change one of the pieces of data inside the block, it would mess up the entire chain of what's happening before it, because each of the blocks are linked together. Now, cryptocurrency applications of blockchain technology often reward participants for doing all this work, right? People don't spend a lot of computing power, buy major mining operations, do tons of cryptographic work just for out of the goodness of their heart. They expect to be compensated for the work. And that is the function of cryptocurrency. It is basically the reward for participants in participating in all of this computing power and all of this work, and the amount of cryptocurrency that is given for solving all these complicated cryptographic problems and adding blocks to the blockchain depends on the the cryptocurrency that you are using on a particular blockchain. It depends on, exactly how the blockchain works. It can be a predetermined amount. It can be a fluctuating amount of cryptocurrency that's given to a node that sort of successfully adds a block to the blockchain. That depends on what blockchain you're on. But it is important to understand that this is sort of the backdrop of what we're talking about. Now, cryptocurrency, it really only is functional if you have a digital wallet that allows you, like a physical wallet, to collect the money, to store it, and then to give it out. And that will become relevant to us as we go through. So many people have heard lately of the Ethereum blockchain because it's become one of the most popular blockchains for NFTs. Part of the reason for that is that Bitcoin was really created only for the purpose of creating a ledger about who owns what Bitcoin. It was not created for having decentralized applications or other types of applications or software built on top of it. And Ethereum was. And that allowed for all sorts of new applications of blockchain technology, including to create non-fungible tokens. Now, the Ethereum blockchain has gotten a lot of press in recent months, given the fact that because it is what's called a proof of work blockchain, it requires a lot of computing power in order to add a block to the blockchain. And this can actually cause some environmental concerns because computers have to work very hard all together in a race to compete a certain cryptographic problem in order to be able to add the block to the Ethereum blockchain, and that can take up a lot of computing power, and thus it's maybe not the greenest practice. And so we'll talk a bit about, as brands, why that matters. It also costs money to transact on the Ethereum blockchain, which is also relevant from an advertising perspective, because if each transaction on this blockchain can cost a consumer somewhere up to $900 to even move one NFT around the blockchain, that's going to be a material disclosure that we as advertising lawyers might want to talk about or disclose. So non-fungible tokens are assets, digital assets that sit on these blockchains and move around these blockchains, most commonly on the Ethereum network. But it is possible to have a non-fungible token on some of the other blockchains, not on the Bitcoin blockchain though. Now, what makes a non-fungible token unique is that one Bitcoin or one ETH is the same as any other Bitcoin or ETH, just like $1 bill is fungible for another dollar bill. A non-fungible token is a unique digital asset, and it's usually associated with something else that sits on the internet, whether it's a digital file, whether it's a piece of digital music, whether it's a piece of digital art. But the token is not the art, and the art is not the token, and that is an important thing to understand. The token itself is basically code, a digital file, and it contains metadata that has, creation, price, ownership history, and a unique ID that's linked to one blockchain address. And this I like as a sort of visual to see, how does this work? Basically, here you have an artist who decides to go to, a token generation app like an OpenSea to mint. They mint a smart contract, and that smart contract creates the token, but it also looks back to the separate art that is stored somewhere else. So this is a good visual representation of understanding that the art is not the token and the token is not the art. And that becomes important from a legal perspective. So when someone creates an NFT, they're basically just executing code. And this confuses a lot of people. Here's a visual example of what a smart contract might look like. It is essentially just code that's stored in a program that runs on a blockchain. And the smart contract is amazing because it has certain rules attached to it, like, every time the code says something like every time, this token gets transferred, X public wallet address gets a certain amount of money. But we have to remember that smart contracts are not prose. They're not, a place where we can upload our terms and conditions. And that becomes important as we think about how to counsel in this space. Now, each NFT only can have one owner at a time, and that's also important. But one thing to note is that owner is probably anonymous. Each NFT owner has a public wallet address that's available and attached to their NFT, but that wallet address is basically just a string of letters and numbers. It's not necessarily attached to someone's actual identity. So that can become a problem when we're counseling in the space or figuring out how to assert our rights. But the NFT itself is just code that associates with an asset and acts as almost like a reliable digital passport that can persist as long as the blockchain persists. So here's a nice visual example of an NFT. You can see this NFT is called Dragon 896775. You'll also note that it was sold for over $1 million. So we can talk offline about whether or not that's a good use of anyone's money. The NFT is associated with artwork by its token ID, which is what this 896775 is. But the artwork is not stored on the blockchain. Remember that visual. It is stored off chain, but it links back, as you can see through this number, to the actual token on the blockchain. Now, we have had a significant uptick in the NFT marketplace in the last year or so. Most NFTs are bought and sold through third-party marketplaces like, an eBay for an NFT. Most commonly, OpenSea, which is, a very famous NFT marketplace that does essentially no verification, much like eBay. It's just, you go up there and you sell something. There are curated marketplaces like Super Rare where you have to apply, and they very careful, or Foundation where they carefully curate who can sell NFTs on their platform. And then there are marketplaces that are created specifically for one entity, like NBA Top Shot, and all of those are functioning differently. Now, we've seen all different types of people sell NFTs, whether it's, the crypto clubs like the Bored Ape Yacht Club or CryptoPunks sort of use NFTs as a way to, the holder of the token can act as a fan club member, and your token ownership can allow you into certain, celebrity-filled events, or to be part of a sort of like a bragging rights club. But there's also been utility for many of these NFT drops. We've seen NBA Top Shot figure out a way to sell old moments. We've seen Bacardi figure out a way to give back to artists by selling royalty streams to users of certain songs. We've seen the Kings of Leon allow token holders to their new album get meet and greets with the band or other special unlockable content. And so it is exciting to see all the different types of use cases that NFTs have brought to the market. Well, with that, though, comes lots of legal questions. And so now, from a global legal perspective, starting with the United States, we're going to talk about what this activity raises in terms of legal concerns, and really talk about advertisers in particular and what they need to think about as they try to navigate this new world. So in the US, there are no specific rules like there are in some of the other jurisdictions that we'll hear about banning any of this activity. It's not illegal to, operate on the blockchain. It's not illegal to sell an NFT, but there is pervasive legal uncertainty about how all this should be treated. And because the blockchain is, and how people are using it, is not a monolith, nor is NFTs, it's very difficult to say whether or not NFTs are legal or blockchain, the blockchain activity is legal, when we really have to look at the actual drop and figure out what is implicated by what's happening. So from our perspective as advertising lawyers, selling an NFT associated with an underlying asset is often like any other rights clearance project. If you're going to sell an NFT that's attached to a commercial, you have to figure out, do you have the rights to all the stuff that's inside that commercial? Do you have the copyright? Are there people inside of it? Are there SAG implications? You have to look at all of your underlying agreements and figure out all the same things that we would in any other clearance project. The sort of problem here, though, is that it's very, if you were to get an intellectual property takedown notice or some other issue, it's very challenging because decoupling the art from the token could create real consumer harm if people have expended significant money on the token. And you also, if you find that your IP is out there being used inappropriately in the space, you have a hard time enforcing it because many of the actors, as we will remember, are anonymous. The Federal Trade Commission has already come out and said that they are interested in this space and in making sure that consumers remain protected in this new area. So there's currently a proposal in Congress, which is called the Consumer Safety Technology Act, which would basically require the Secretary of Commerce and the FTC together to study blockchain technology and digital tokens like NFTs and talk about whether or not there's anything unfair or deceptive that could come from that, and figure out how to prevent that as well as fraud. Many people have heard about the securities risk attached to NFTs. We are the Global Advertising Lawyers Alliance, so I won't pretend to play securities lawyer on television, but I will say that the securities risk that comes in this space really comes down to whether or not an NFT or a product or service in the digital token space is acting as an investment contract. So the more that you are involved, or your clients are involved in dropping an NFT that seems like a place for people to invest or make money, there is a potential for securities risk, and I would advise you to get outside counsel advice on that. Now, we already saw NBA Top Shot and Dapper Labs get into some trouble with a class action related to whether or not their Top Shot project is this securities violation, so it's an important thing to pay attention to. Gambling laws can also come up in America because, over the course of the last many years, most of the sort of in-game virtual currency that we've seen in the video game space, for example, has really not been something valuable that can be taken off the game and used for real money. And now with blockchain technology, we are seeing the possibility for in-game currency to be converted to real money. And we worry a bit about whether or not that could implicate some of the patchwork of gambling laws at both the federal and state level in the United States, again, depending on the drop at play. The Commodity Futures Trading Commission has also said that depending on the structure of a project, certain digital assets can be commodities. And so, you want to figure out if there's a futures possibility in your NFT drop. And if you are, if your NFT drop can look like trading in futures, you want to think about whether or not there could be commodities issues. There's also a lot of money transmitter laws on the books that relate to digital assets, including non-fungible tokens. Many the federal rules, as well as many state laws, often require that if you are the custodian of certain currency, that you have appropriate licenses. Some of the digital currencies and the projects can implicate those laws, including in New York, where we have a BIT license. So it's important to, again, make sure that you're speaking to counsel on any particular NFT drop and seeing what's at play. As we talked about before, these actors on the blockchain are often anonymous. So in the United States, we have serious rules about not doing business with sanctioned countries, with individuals who are engaging in prohibited conduct. And given the fact that we often don't know who we're transacting with on a blockchain, there is real concern about whether or not we are violating sanctions rules when we're engaging in some of this activity. So again, important to think through for each particular NFT drop, whether or not there's a way to sort of know your customer or know who you're dealing with. Tax is selling and trading digital currency can often have tax implications like it can for any other type of property. So something to pay attention to. And then just the practical considerations. Are you going to get PR backlash for having an NFT drop that doesn't really make sense, that's not green, that isn't providing consumers with utility or otherwise hurts them? Are you thinking about the environmental considerations? Are you a green brand that's going out there and talking about how sustainable you are, and then deciding that you actually want to drop an NFT, which has, in some instances, real environmental considerations? Do you have the right vendors, and who's opening the wallet? It's like opening a real bank account. And then you also want to think about where are you storing the underlying asset? Do you have terms and conditions that consumers can understand, so they understand what they own and what they don't own, that they understand the difference between the art and the token, and that they're not necessarily getting rights to the underlying IP when you give them an NFT, but really just the right to the NFT itself. You also want to think about brand safety issues. We've seen a lot of mischief in this space with hackers coming into brands' wallets and sending racially offensive or pornographic tokens or other brand safe, not brand safe content into brands' wallets. And in this space, you really can't control for that. So you have to be aware of how the technology works and how to make sure that your brand is comfortable with operating in the space. And I'll now turn it over to Brinsley. Thank you.
Very much, Hannah. That was extraordinarily informative. Left me wondering why anybody would want to get involved in NFTs. Seems like an awful lot of risks and problems. Hannah, the next slide, please. I don't think I can do it, can I? So I'm going to...
Yes, I got it.
Probably rely on you. So the UK, probably the first thing to say is that in the United Kingdom, the concerns about NFTs is really as a function of the concern about advertising and marketing and promotion of cryptocurrencies, rather than around NFTs in their own right. This is quite a slightly busy slide, but you can see there the ASA is the Advertising Standards Authority. That's the UK's non-statutory self-regulatory organisation, but who do the lion's share of advertising regulation in the UK, and only those things that kind of either are very serious, like financial services regulation or medicines regulation, get picked up by the statutory regulator. And even in those highly regulated sectors, the first sort of line of defense, if you like, or the first line of enforcement is often the Advertising Standards Authority. And last November, they issued a statement saying that they were putting a very grand statement that cryptocurrencies and NFT advertising was a red alert, high priority issue for them. And they were concerned that people could be drawn into investing large sums of money based on a poor understanding. And that they wanted to make sure that ads for cryptocurrencies didn't mislead customers. And I think what we'll see emerging in the ASA's policy is this concern that where an NFT is being promoted, it's being promoted as a kind of door opener. You want this NFT, therefore open this cryptocurrency account. And then once you've run the cryptocurrency account, you're in this world, as you can see from that slide, of an unregulated cryptocurrency. So I think the main cause of the problems is that at the moment, cryptocurrency is unregulated. As we'll see, that is likely to change. So we might actually be in a particular window of time at the moment where cryptocurrencies per se are likely regulated. They are going to become very strictly regulated, like any other financial promotion. And when that happens, then I think the ASA's concern will kind of be resolved, because once these things are regulated like other financial products, it's going to be much more difficult for these kind of bad practices to continue. The sorts of things that you get because they're unregulated is this lack of appropriate risk warnings that you would see on other kinds of investment advertisement. Also ads, and this is perhaps peculiar to NFTs and crypto, ads taking advantage of consumers' inexperience and incredulity. I think this appeals, the NFTs appeal to the person in the street who is not a sophisticated investor in a way that other kinds of financial products wouldn't, and that most people would only be investing in if they were getting some kind of professional advice. So there is a particular issue there. And also just irresponsible advertising, creating, for example, a sense of urgency about having to buy. Yeah, next slide, please. In going back even further in time, back to July 2020, the government issued a consultation about bringing some crypto assets into the scope of financial promotions regulations, and that process is ongoing. It's been rather confusing. Lots of regulators seem to be looking at this. At the moment, what we don't know is whether this bringing into the sort of the full fat system of financial promotion regulation will apply to all crypto assets, including NFTs, or only to those fungible crypto assets like Bitcoin and Ethereum. We're yet to see, but at the very least, it's going to capture things like Bitcoin and Ethereum. And at the moment, the Advertising Standards Authority hasn't really distinguished in its treatment of fungible and non-fungible crypto assets, but it does seem that their main concern is with, if you like, the fungible crypto assets and the possibility that people would invest in something thinking, for example, that it's on a promise of going up in value when in fact it might lose value. When I put together this deck a few days ago, so last week on the 1st of February, the ASA hadn't made any specific rulings, certainly none that I could find, I don't think there are any, purely about NFTs, only where they were being used, as I say, as a door opener for other types of crypto asset investment. And in fact, the ASA publishes their adjudications every Wednesday, and yesterday, very unusually, there were no formal adjudications published. So that statement remains true. Next slide, please. So just looking at a couple of these where there has been an adjudication. This one was for Papa John's Pizza, where and one thing to note here, the ASA investigated an ad for promotion that offered free Bitcoin with the purchase of pizza. So I think if you spent £30 worth of pizza, you got £10 worth of Bitcoin. So you didn't actually, you got your pizza anyway, if you like. This was a free gift type promotion. It was the ASA who instigated this, which is interesting in its own right. The vast majority of ASA investigations are instigated by either consumers or competitors. Occasionally the ASA do themselves, but this does indicate that this is a live issue for the ASA, and so they're going on the front foot. And they would probably say quite reasonably, well, we think we need to do this because if consumers are being misled successfully, then they won't know they're being misled, so they won't know to complain. So it takes us to intervene to protect them from this. The mischief here was, as I say, the door opener. In order to get your £10 worth of Bitcoin, you had to open a trading account with the company that Papa John's were partnering with. And the ASA thought, well, using a pizza to encourage people to open a crypto account is then encouraging people to engage in high-risk investment, even though Papa John said, well, look, people can just open the account, get their £10 worth of Bitcoin, sell it, and trouser the money. But the ASA said, no, we still think there's a potential here that people will be getting involved in these things they don't understand. So they upheld the complaint. Next one, please, Hannah. And similarly, with this promotion for Arsenal, who are very much the second and less favoured soccer club of North London, only supported by very gullible and not terribly intelligent people. And so they needed to be protected as well. So again, another ASA getting involved themselves. This involved fan tokens, and it was encouraging people to get this app, Socios, and then you could get the fan tokens. And then, for example, you could vote on which song would be played in the Arsenal stadium before they lost. And the ASA said, well, this promotion of the Arsenal fan token, again, it's misleading, it's irresponsible, you're using it again as a door opener. Initially, when this was done, you couldn't trade using this Socios app, but it was still being run after a point when it could be traded. And so again, the ASA, they were sort of the prosecution and the jury. The ASA then decided that the ads irresponsibly trivialized the investment and didn't have the investment warnings. We'll see. Now, Arsenal hotly disputed this finding, and I'm sure Papa John's did too. But maybe as a function of being a self-regulatory organisation, it's not easy to challenge ASA decisions. It can be done, but the hurdles are quite high. So another example here of an upheld complaint. Go to the next slide, please, Hannah. So whilst these complaints have been going on in other parts of the forest, the Financial Conduct Authority, which is the statutory regulator, so the lead regulator, they are conducting a review, as is Her Majesty's Treasury. I have to admit I'm not clear on the dividing line between their responsibilities. Treasury is basically a government department, whereas the FCA is the sort of statutory regulator. And as I said, it's pretty clear, I think, the cryptocurrency is going to be regulated by the FCA. Pure NFTs, it's less clear. And the emerging ASA policy is that if you're using an NFT to encourage people to set up a crypto wallet, then you kind of fall off a cliff, and you ought to be giving all these warnings about the risks of investing. If you could just go to my last slide then, please, Hannah. So the sort of the lessons that emerge from the kind of 4 or 5 ASA decisions that we've had, including the 2 that we've looked at, are that there's some key information that needs to be included in adverts. You've got to say cryptocurrency is unregulated. You mustn't take advantage of the consumer's inexperience or credulity. You have to consider the financial knowledge and experience of the audience. So if you're targeting something at young football fans, perhaps then they're not going to be terribly sophisticated. Don't trivialize the investment, for example, by linking it to the purchase of a pizza. Don't exaggerate the return. So if you see things, if you'd bought £10,000 worth of Bitcoin in 2012, now it'd be worth £1 million. That kind of thing, avoid. Oddly, in some ways, is you're supposed to make clear that capital gains tax might be payable. We're not aware of any other types of investment where that has to be put on an advert, but then where you have regulated investments, there's lots of controls on the whole landscape. So maybe it's not necessary. And the reason why it is here is because at the moment, cryptocurrency isn't subject to all of these other restrictions. Include all the material information, in other words, all the information people would need to make an informed decision. Give the value warning, cryptocurrencies can go down as well as up. If you do make a projection, you have to explain how it's been calculated. And you have to be clear that past performance is not a guide for future performance. So all in all, there's quite a lot of information that has to go in cryptocurrencies when they're advertised and when NFTs are used as this kind of door opener to encourage people to set up an account or a crypto wallet. And I think we're pretty certain that during the course of 2022, we're going to see cryptocurrencies brought within the fold of financial promotion advertising regulation by the Financial Conduct Authority, and the whole regime is going to become much more restrictive. That was it from me. Thank you, Hannah.
Kelly?
Thanks, Hannah. And happy to join. Thanks so much for the wonderful introduction to set the table for the conversation today. Canada is very similar to the UK and the US in that securities laws are one of the driving concerns when it comes to NFTs. And a very important consideration if brands are going to engage in this, particularly given that they're not going to have the expertise necessarily from other business activities. So, similar to the UK and the US, to the extent that the NFT activity is regulated under securities law, there would be a very complicated regime of provincial legislation that would govern the activity. For example, and maybe most notably, there are potential registration requirements as a securities dealer or an advisor or as a securities marketplace. And that obviously is going to apply to any cryptocurrencies. So that's an area that securities regulators are at the forefront out and dealing with in Canada. So any cryptocurrencies that are associated with the blockchain on which the NFT is minted are obviously going to be, likely regulated. But the concern clearly is that it could also apply to the NFTs themselves. So that's something that you're going to need to, particularly if it's an ongoing, minting of NFTs, it's an issue that the advertiser is going to have to engage an expert to make sure that they're not going to be, potentially subject to registration requirements. And notably, securities legislation has its own provisions that prohibit false and misleading representations. And also, which is kind of unique in Canada, perhaps, a broad power for regulators to enforce against conduct that they determine is contrary to the public interest. So these kind of broad public interest powers raise regulatory risk, not just for parties that are likely regulated as a cryptocurrency or otherwise, required to be registered under securities legislation, but for unregistered parties or folks who are not actually in the industry in the same way. So an example of how this broad power could be applied would be, for example, if an advertiser was continually engaging in practices that the regulators, thought were exploitative to investors, that's where these kind of broad public interest powers could come in and parties that are not, actually advisors or dealers could be subject to these laws. And they're pretty significant, up to $5 million plus disgorgement of any ill-gotten gains. So something to keep in mind, particularly if the activity is significant. And the other considerations similar to the UK and the US, anti-money laundering laws, are you need to be registered with FinTrack, which is Canada's financial intelligence unit. And then taxation, right? So bringing in your accountants, the folks internally who have to file the advertisers' income taxes, for example. If brands are buying and selling NFTs, there are going to be potential tax implications. And these purchases are not anonymous. The Canada Revenue Agency has won court battles to get customer data from crypto exchanges like CoinSquare, and coordinates with other exchanges to help track the movement of these digital assets. And in general, the CRA, the Federal Taxation Authority, treats cryptocurrency like a commodity. And so what that means is, any income that's going to be derived from the transaction involving a cryptocurrency is going to be business income or capital gains. And so when you buy that NFT, you're cashing out your crypto currency. So that's going to have a tax implication. So something to think about from an advertiser perspective, because if you're going to be buying and selling these NFTs, they are in fact a commodity that's subject to income tax in Canada. And then there's also, sorry, Hannah, just still on that one last slide. There's also GST, HST sales tax implications. So fungible cryptocurrency, certainly like Bitcoin and Ethereum, are going to be, money. But NFTs don't really readily meet that definition. So, if you're going to be selling these NFTs, you're going to want to engage accountants to make sure that you're, charging a GST if your sales are going to be over $30,000, so that you can remit it to the CRA. So on the next slide, the applicable law, obviously, the securities legislation. Intellectual property is a huge one. And I think a huge consumer misconception right now is whether there's an actual assignment of any underlying intellectual property. People think that when they're buying an NFT, they're actually buying the underlying art. And I don't think that there's a lot of widespread understanding that that's not the case. It's not necessarily an assignment on its own. So that's something that needs to, it kind of blends into misleading representations, which are obviously governed in Canada under the Competition Act, and consumer protection legislation prohibits making false or misleading representations. And our self-regulatory code has analogous provisions as well. When you're making a representation about selling an NFT, what are you selling exactly? And if you're not going to be assigning that underlying intellectual property, that's pretty material. And notably, the standard from kind of a general advertising law perspective is, you as an inexperienced viewer, and I think that most consumers, most NFT purchasers are very inexperienced in this. It's a very new area, and so I think that puts a lot of onus on the advertiser to describe what they're selling and describe, what they're not getting as part of that transaction. Another interesting issue in Canada, which makes it perhaps a little bit more unique than other jurisdictions, is we have a fairly robust consumer protection regime, including the regulation of contracts between merchants and consumers that are conducted online or where people are otherwise not in the same location, like it's contracted remotely. And these statutes apply to the purchases of goods and services by consumers who are located in Canada. So the location of the merchant is not relevant to that analysis. The location of the consumer is. And this is kind of a theoretical issue at this point. I'm not aware of any litigation in this area. And it is still kind of an open issue as to whether NFTs would be regulated as goods or services for the purposes of these consumer protection statutes in Canada. A similar analysis to, virtual items that are traded in video games. Is this virtual item something that is real? Is it governed by the same statutes? So if these consumer protection statutes do apply, there are significant potential risks for advertisers who are selling NFTs. A key cornerstone to these, these statutes is once you are engaging in internet sales or online sales, you are required to disclose certain things prior to entering into the transaction. And then after the transaction, you need to provide a copy of those disclosures as well. And failure to do so can give the consumer, the purchaser of the NFT in this case, the right to rescind their agreement, in addition to collect damages. And this becomes a big problem when we kind of apply it to the NFT space, because some of those disclosures are who is the merchant and what is their contact information. And there's been many sales where these famous sales, in fact, where the merchant is not disclosed, and there's a lot of speculation about who those merchants actually are. And the other obvious challenge is if consumers are rescinding an agreement for failure to disclose that, how do you do that? It's obviously a big challenge to give a refund in the context of a crypto purchase. And even if you're able to make it that far, there's going to be sunk costs for the transaction, and as Hannah mentioned, that can be hundreds of dollars. So if you look at these kinds of sales, including on a class basis, you could really open yourself up to quite a lot of liability if you're not thinking through all of these potential. So just on the next slide, please, Hannah. Some key takeaways from the Canadian perspective, obviously want to avoid any securities pitfalls, engage an expert in securities law. Things that you should, kind of avoid that are quite obvious are, don't be making representations about, the risk or, an investment return of purchasing an NFT. You want to avoid some particularly regulated words, preferred, guaranteed, liquid, like indemnity. All of these kinds of things will, increase the risk. You don't want to make any, I think, representations about an investment return. Certainly don't overstate them, because then you're going to be getting yourself further down the road into the assessment that this could be regulated by securities law. And there are opportunities to conduct some due diligence on parties. There are public registries of entities that are registered as, marketplaces or dealers. So to the extent that you're going to work with third parties in this space, conduct some due diligence to make sure that they're following the laws. And in your representations to purchasers, be clear about what you're transferring, right? If you're not transferring the underlying asset, that's going to be a significant change to how you present the NFT offering. And then, working through these kind of specific issues like the consumer protection risks that I just talked about. So, what are you going to do if people ask for a refund? Are you going to comply with those requirements? All things to be thinking about.
Great, thank you so much. And now we have Dina from Russia. Dina.
Hello, thank you very much. And I would like to move you to the whole other part of the world, to Russia, which funnily enough have very similar experience dealing with NFT as other countries which speakers have already told about. So there are no clearly established rules for NFTs, and it is generally understood that the possible regulation of the NFT will depend on the assets underlying the NFT itself. So NFT is not in itself an IP asset, it's just a digital certificate linked to the digital asset underlying such NFT. And in order to understand how your particular drop will be regulated in Russia, you would need to refer to a whole different set of legislation, which starts from the civil code and some other general legislation, such as law on advertising or law on the protection of the consumer's right, and refer to the more specific laws which are specifically devoted to the digital financial assets. One of them is the law on the investments platform, which was initially established to regulate the crowdfunding platforms, and it has established the term of utility digital rights, and the law on the digital financial assets, which was initially aimed to regulate different digital assets and different crypto-related projects, including cryptocurrency itself. And if we refer to these key three types of digital objects, it would be digital financial assets, digital currency, and digital utility rights. And if we're talking about NFT, we need to understand whether it can fall under any of these categories, because in this case, it will be regulated. So digital financial assets is a digitized right to monetary claim, to possibility of exercising the rights under the securities, the rights to participate in the capital of non-public joint stock company, or the right to demand the transfer of equity securities. If your digital assets under the NFT is something close to this, this NFT will be regulated, and the transfer of them should be conducted through a separate platform. The operator of the platform will need to obtain a status under the Russian law, etc., etc. With respect to the cryptocurrency, the definition states that it is a digital code. It can be used as a means of payment or investment, and there is no single obliged person with respect to this code. And with respect to the cryptocurrencies, our Russian legislation is currently quite sparse. It just established the ban on the accepting cryptocurrency as payment and on distribution of information that cryptocurrency can be accepted as a payment on certain platform or at marketplace or something like that. With respect to the utility, digital utility right, I think that's the one that's correlates with NFT the most, at least with art-related NFTs, because the utility digital rights provide digitized right to demand the transfer of certain goods or the results of the IP, or the right to use the results of such IP, or the right to demand the performance of work or the provision of services. Similarly to the digital financial assets, if the underlying asset linked to the NFT fall under this definition, respective transfer can be done only through specific platform. And again, Russian regulator, the central bank, will look at this activity very closely and apply additional requirements to the operators of this platform. However, if I can see the next slide, please. We see that in practice, there have been several quite prominent NFT placements in Russia, which includes Hermitage, which decided to auction in cooperation with Binance some of its most valuable masterpieces by Claude Monet, Leonardo da Vinci, Giorgione, and several others. Artplay Design Center also made the NFT placement. There have been certain placements to support independent media and mass media. So all these projects has applied quite a pick and choose approach to these regulations. And basically, they have been obeying only the ban on the accepting the cryptocurrencies, because mainly I think this approach was driven by the fact that the Russian regulator is very wary of cryptocurrencies, and it pays close attention to all major projects which involve distribution and other use of cryptocurrencies, including the use of them as payment. And this is the only prohibition which is currently very clear on the market, and the marketplace usually observe it. With respect to the other restrictions which may apply depending on the type of the asset, the market is currently developing, and there have been very few players which have obtained relevant status, and we are currently waiting to see what CBR has to say on this matter. If we refer to the next slide, we can see that like the main points which should be considered by the advertisers when they intend to drop an NFT or to launch certain NFT related project in Russia. First of all, you need to consider what rights will be associated with the NFT itself and with the asset linked to the NFT, and how it possibly can be classified under the Russian law, and consider possible implications coming from that, and with that will depend entirely on the case. You cannot waive general provisions of the advertising and IP laws, so in any case it should be clear, reliable, etc., etc. So anything that you would take into account during usual advertisement campaign, you will need to take into account if you're doing something with NFT. Tax implications is always a good thing to keep in mind. And given that the NFT market seems to be only growing, and the amount of money generally involved in NFT drops and their consequent distribution is getting higher and higher, we expect that the Russian regulator will pay more attention to this sphere in the future. We didn't see any specific drafts on recommendations so far, probably because the CBR is very involved in establishing some regulation for cryptocurrencies in Russia, something more specific than just general ban on the payment in the cryptocurrencies. But we think that after that, it is highly likely that they will adopt some recommendations because they are very protective of the Russian consumers, and any financial instruments or crypto-based instruments or something similar will likely to attract more attention and to receive some special guidance from the CBR. I think that's all for Russia. Thank you.
Thank you so much. And I just want to remind people before we get started with folks from Italy that you can have questions answered in the Q&A on the right-hand side of the screen. So now I would like to invite Lydia to speak about what's happening with NFTs in Italy.
You see me now and hear me? Sorry. Sorry for the inconvenience. I was saying thank you, Hannah, for inviting me, and Gala for inviting me as well. As far as Italy is concerned, blockchain, NFT, digital assets, and digital wallets are not illegal, but a comprehensive legal framework is still yet to be set out. Most recently, Italy enacted legislations that deal with blockchain environment and some of its players. Cryptocurrency has been partially regulated, apparently considered a more sensitive argument when compared with other kind of crypto assets or crypto activities like NFTs. More specifically, Italian law provides for a definition of blockchain and smart contracts since 2018. In particular, a smart contract is defined as a software that operates on a decentralized ledgers and is automatically enforceable on two or more parties based on what is provided for in the contract. The smart contract, according to Italian law, is equivalent to a written contract as long as the parties are identifiable. This is an important point since, as we know, transactions on blockchain can be anonymous. And if this is the case, the smart contract does not meet the formal requirements of written form, which is required in some cases, for example, to prove the existence of a contract, for example, in court. Furthermore, the providers of virtual cryptocurrency mediation, conversions and settlement and e-wallet services are subject to anti-money laundering and suspicious transactions reporting rules. The pieces of Italian legislations just mentioned relate to fungible tokens, which basically means cryptocurrency. But as far as non-fungible tokens are concerned, it has been pointed out that in certain cases where the speculative purpose is predominant, the application of security regulations might be triggered by NFTs. And this is true when NFTs fall within the definition of financial products under CONSOB regulation. CONSOB is the regulatory authority in Italy on security products. An NFT can be classified as a financial product when it is offered and presented as an investment product and when the final goal is mainly speculative. Whether an NFT falls within the definition of a financial product is something that can be verified on a case-by-case basis, and this evaluation cannot be done in advance. Next, please. Since NFT can be considered a financial product under CONSOB regulation, just mentioned it, this may trigger the application of disclosure and other information duties on advertising messages relating to the offering of a security. In the light of the above, it is advisable to proceed with caution when there is a potential security risk due to the nature of NFTs. Disclosure and information duties might also be triggered by the sale of NFTs that cannot be classified as security. Indeed, NFT may fall within the definition of digital content or digital service, both recently added to the Italian consumer law. There are no precedents or statements from the competent authority that can help us understand without any doubt whether an NFT is a digital content or a digital service, but there are good arguments to say that an NFT falls within the very broad definition of digital content, since it is made by data that are produced and supplied in digital form. If this were the case, Article 59 of the Consumer Code would be applicable, and pursuant to this provision, the right of withdrawal would be excluded from contracts that regulate the sale of digital content as long as the supply of a digital content through a non-tangible medium starts with the consumer's prior express consent and acknowledgement that they are forfeiting their right of withdrawal. Therefore, an exhaustive information to the consumer might exclude the enforceability of the right of withdrawal. And this is a very sensitive point, since the exercise of this right, when it is referred to an NFT, presents some more than one technical issue. The return of NFT is one, for example, of this issue. The refund is another one. The gas fee is the last one. So this could be a very sensitive point. Regardless of whether the NFT falls within the definition of digital content or a digital service, what is certain is that the sale of NFTs is covered by Italian Consumer Code, which provides a number of disclosure and information obligations for the purpose of protecting the final consumer. And such provisions are mandatory and enforceable regardless the law applicable to the terms and conditions of a certain transactions when the consumer is located in Italy, and any different agreement could be considered invalid. Again, it is therefore advisable to proceed with caution when the international campaign for the sale of NFT is launched, and we recommend to check terms and conditions along with Italian Consumer Code. As in other countries, of course, NFTs are subject to current provisions related to fair and transparent advertising. An NFT campaign must not make false or misleading representations like ownership of the underlying IP assets or easy money gaining, etc. And finally, the promotional purpose of the message related to an NFT must always be properly disclosed. Next, please. Yes, Italy is still at a very early stages of this market. Cryptocurrency and NFT are known on the market, but the phenomenon is not yet mainstream as in other countries. Italian luxury and fashion brands are leading this new market, for example, Dolce & Gabbana and Gucci, among others. But we are seeing also several cases of influencers, basically tech influencers or art influencers, that are launching their own NFT drops. In the cases of brands, the main concerns they have is related to the regulation of IP rights through license agreement that must protect the IP asset to the maximum extent possible. Sometimes the project is the result of a collaboration between two brands, one famous in the fashion industry and the other one, for example, well placed in the NFT industry. This is the case of the collaboration between Gucci and Superplastic, for example, that together launched a new NFT drops yesterday. And again, the regulation of the respective rights over the NFT has been crucial. Brands and influencers are opting for the so-called utility NFTs. This kind of NFTs has leverage on the community that brands and influencers already have or want to increase. Utility tokens serve a specific use, such as use on a platform to redeem a special service or to receive preferential treatment to services in any ecosystem. This is the case of the NFT drops sold by Dolce & Gabbana and Gucci. The buyer is entitled to certain additional facilities like physical goods, exclusive experiences, etc. In the same way, influencers use utility tokens to allow followers to attend events, obtain special prices for merchandising, spend some time with the influencers. It is good to know that the regulation of the utility token in Italy is still unclear. Depending on the kind of service or utility attached to the NFT, it might have a different treatment, also from a tax perspective. The NFTs environment raised the interest of the European legislator. A proposed regulation on crypto asset markets is now under discussion, since the EU Commission is of the view that where crypto assets are not covered by EU financial regulations, the absence of rules applicable to services related to such assets leaves consumers and investors exposed to substantial risks. And so once approved, this EU regulation will hopefully contain a comprehensive legal framework for NFTs, not following into the financial regulation scope of protections. And it will provide, hopefully, again, clear provision on qualification of NFT, authorization obligations, and information to the market. Thank you.
Thank you so much. So now we're going to move on to Juan Carlos from Colombia.
Sorry, minor mishap. In Colombia, we have, next slide, please. In Colombia, we have a very funny situation, and that is that under our constitution, everything is legal unless it's declared illegal. Basically, you can do anything unless there's some kind of regulation that prohibits it. So when the blockchain and all the cryptocurrencies started to become a trend, which certainly is being used by a lot of investors locally, our authorities didn't know what to do. They were like, yeah, there's something that we have to deal with, but we're not clear. So there was a task force that was created by all the possible governmental entities playing a role on the regulation of currencies or securities or any sort of finance. So you have the central bank, you have the banking superintendency, the superintendency of companies, the financial regulation unit that basically takes care of other players in the financial market, the unit of financial information and analysis, which takes care of money laundering, and the technical council for public accounting. And they came to a very funny conclusion in the sense that they declare that cryptocurrencies are sort of useless and lack value, which is contrary, obviously, to common sense. So if you see, they came to claim that it's not a currency, that they are not money for legal purposes. Basically, that they don't have a value as cash, or they cannot be a cash equivalent. There is no obligation to receive them as a means of payment. So, of course, if you have an agreement whereby you commit to provide a certain amount of cryptocurrency, technically, it is without any enforceable qualities. You cannot call it exactly illegal, again, because it's not been declared illegal, but this task force comes to a conclusion that you cannot do much with it. Again, as it is a task force, the situation that doesn't come as a regulation, more like a think tank on a sort of conclusions of how to deal with it. But then at the very end of last year, next slide, please. Thanks. The Unit of Financial Information and Analysis, the UEF, was aware that obviously all this information on investment on blockchain and cryptocurrencies, and obviously that had a huge upside on the market, and now we have the huge downside. But they were very worried that a lot of money laundering was taking place in this environment. So they wanted to come to a regulation, in this case now enforceable, in which they set up very, I will call it in a rush, and without a strategy of how to deal with it, that they know that nobody is reporting. I mean, there is no place where they can go and obtain information from third parties about virtual assets, about what is going on with cryptocurrencies. They don't know if any of the taxpayers have crypto assets or not. They don't have any, I mean, from the financial system, from the commercial system, they can get information about what the taxpayers are doing. But the crypto assets, that's not the case. So they decided to create a mandatory registry of crypto assets. That is, now every Colombian, if they own any token, no matter what the quality, the nature, the sort of blockchain basis where it's used, must go and register and report that they own them, which is sort of, they don't know how to do it, so they put everything in the same basket. And of course, within this basket come the NFTs. The NFTs is a virtual asset. So if you own a virtual asset of any possible size, that could be a silly logo, that could be a song, that could be a work of art that's worth millions of dollars, you must go and do a registration about it for tax purposes and money laundering control. But on the other hand, we have the same authorities claiming that this asset is worthless. So we have sort of a schizophrenic approach towards these items. Next slide, please. So again, for I guess the 2 or 3 cases that we have had clients requesting us advice because they want to run a campaign using an NFT, well, we can tell them not do it. Do not do it. I mean, please don't think about it. We know that it's a trend, but at this moment, with this very ambiguous regulation happening around it, you run contrary to the Consumer Protection Act. That is, that you will have necessarily to provide to the consumers a lot of information of an atmosphere, an environment that is not clear, because basically to make it understandable, accurate, how to, and as all of the other panelists have mentioned, when you want to deal with the NFTs, you have to have access to a digital wallet, and that is not, it's not yet that mainstream, it's not that clearly understood, it's not properly operational in what you have to convey about the value of what you're offering. So you open yourself for a lot of claims or let's say attacks by your competition or disgruntled consumers. Please, next one. Next slide. Nevertheless, even with this environment, the Colombian, as I said, decided to offer a mining contract, in which NFTs are minted, still with a limited scope. Basically, that is that the production that is taken out of the mine will be reflected on a token. So the tokenization is mostly a way of auditing what is happening on the mine. So as you produce certain amount of iron ore, you will be able to produce an equivalent that is reflected on a token. And that was for the purposes of auditing the production of the mine more than the commercialization. But then again, if you have a token and you want to put it on the market and you want to commercialize it, you can do it. Certainly, it must have a value, and it can be made equivalent to cryptocurrency, but still the implementation, the long-term implementation, it's experimental. I will say that everything we're talking about is in experimental throes. They're trying to figure out what to do with them. Next slide, please. This case involves more than and Colombia, it was an experiment done by Comebol at the end of the last Copa America, in which they wanted to create something trendy, new, original. So they decided to use the platform of Eternity, and for the final, for the two teams that reached the finals, that was Argentina and Brazil, they decided to create a special set of digital collectives that the public and the viewers will be able to obtain if, obviously, there was a joint sponsorship event with Eternity, because they wanted to be open to the Latin American consumers. So they will be able to get certain NFTs that will be reflected by the acquisition of certain units of this cryptocurrency. And they had a value, obviously. That could be an equivalent. You could buy it in dollars or pesos or the other reales or any of the other currencies of the region, and you will be able to get the copies. But that was to open the idea that everything was not Ethereum or none of the other cryptocurrencies, but they were more available. So this was an advertising campaign to push the cryptocurrency and make it recognizable more than anything else. So far, no issues were claimed against them. And it worked smoothly, but it's one of the, let's say, opening acts when the NFTs were first heard by the global public, like, what's that? And then they have to explain it a little bit. Next case, please. Okay, next slide. This is the latest one. As Brinsley was mentioning with Liverpool, we also have this football team, which is called Millonarios, which have the largest amount of followers in the country. Some will claim not exactly the most successful, but it's certainly quite recognizable and prestigious. And they decided to create a new way of approaching their fans and creating alliance with the people who attended the stadium. So they decided to launch a fan token. And this fan token will provide them access to certain goodies and special events provided by Millonarios, and it will be obviously non-exchangeable and provide an identity with the owner of the token, that it was like an allegiance, a certainty of allegiance. But Millonarios have been now in discussions to see how they can monetize or make it more attractive or provide some kind of value, because it's got a limited amount of the funds that it will be taking. So it's one of those campaigns that they decide to go on the open. The consumers don't know exactly when they go and buy one of these tokens, what they will get, what is being offered, for what they paid for, exactly what it conveys. But nevertheless, even though that it's murky in the context of advertising law, it was recently launched, and from the perspective of what will happen, it will be the minery on the coal mine of future claims, because it's one of the ones leading let's say the advertising campaigns. And well, that's the situation now, as we see, which it's a very complex and evolving atmosphere, and we'll see what happens next. So from that, we go to China.
Thank you so much, Juan Carlos. And now, as many people probably want to hear, we will hear from Justina on China, one of the most interesting jurisdictions in the cryptocurrency space. Justina?
Thank you, Hannah. China is quite known for tough regulatory environment, banning all kinds of cryptocurrency related activities and promoting its own digital yuan as only legal digital currency in the country. Nevertheless, interest in the booming market for the non-fungible token is as strong as in China as anywhere else in the world. However, NFTs markets in China and auto China are quite different. In China, NFTs offered by technical giants generally referred to as digital collectibles rather than token. The forms of NFTs offered by these technical giants are quite limited basically limited to arts currently and cannot be resold for profits. To understand this unique market phenomenon in China, let's have a quick download of the legal environment in China for virtual currency and digital assets. Next slide. It is generally understood that virtual assets is protected under the Civil Code as one kind of civil property rights, which serves as a legal basis for any Chinese to own digital currency or any virtual assets. However, the law did mention that such protection is subject to laws and regulations for protection of such specific digital assets. Unfortunately, we don't have any laws issued yet for NFTs. So it's that legal status is really pending. On the other hand, China government has taken very strong position against cryptocurrencies, including banning of ICOs and trading. Further, on September 24th last year, our central bank, PBOC, issued a regulatory document to control the speculative risk of cryptocurrency trading. It used the words of virtual currency in the notice, so it may cover some wide definition of what could be virtual currency. Among the others, it clearly states that all cryptocurrency transactions are illegal. And further, it states that overseas cryptocurrency exchange providing service to any Chinese residents through internet is also illegal. That's a very interesting statement. Also, it states that the employees of those exchange in China, as well as any other companies, organization, or individuals, whoever provide any kind of service to those overseas exchange will be held liable in accordance to relevant law. That means no payment company can provide a payment facility to those exchange overseas, and no internet companies can provide any technical support for those exchange either. The notice also warned the legal risk of investing in cryptocurrencies by any Chinese. It even mentioned that if any companies or individuals invest in cryptocurrencies, which against the public order and the good customers, which is quite a broad definition, the relevant civil legal actions are invalid. That means if any individual company selling virtual currencies in China, and that contract might be held as invalid, and then whoever get involved will take the liability and the losses caused by themselves. Next slide, please. That explains why the NFTs offered by tech companies in China are quite different from the remaining of the world. First of all the NFTs offered is named as digital collectible. That's quite a neutral term. Avoid using the word of token. Secondly, the forms of NFT are quite limited, mostly related to artworks. Third, it is offered not in the public blockchain as everyone familiar with, rather private consultant blockchain of these tech giants. Last and most importantly, those NFTs are not tradable, cannot be resold for money. Next slide. However, the stricter legal requirement didn't stop brands trying to make efforts to incorporate either cryptocurrencies or NFTs in their marketing efforts. Some failed, some are quite successful. This is a car manufacturer which officially announced on Weibo, that's Chinese version of Twitter, that it will be the very first automaker in country accepting Bitcoin as payment for car purchases. Kind of give clients a space to think bigger. However, after the announcement released on Weibo, the company realized that it's not in compliance with laws, and it removed such post and instead post an apology. Next slide. This is a case about JD, that is one of the tech giants in China. It's an e-commerce and tech company. Its tech arm, JD Technology, announced that it offers free NFT badges to users registered for the company's annual tech summit. That is called JD Discovery. That one is quite successful, and the NFT badges circulated is compliance with PRC law and no legal issues. Next slide. This is McDonald's collection called 188 Digital Assets. Yeah, it's avoid to using the term NFT, but actually it's one of the NFT. And the distribution is among selected customers and employees, and it is free. It is compliant with the laws and no legal issues either. Next slide. Chinese regulatory landscape of virtual currency is still evolving. NFT's legal status is unclear at this stage. Whether it will be treated the same way as cryptocurrencies or not are really pending. But generally speaking, brands can market NFTs in China. Key takeaways for marketing would be, first, it is advisable to use the term digital collection or digital collectible rather than currency or even tokens to avoid unnecessary connection with the cryptocurrencies. And of course, it should be clear that such NFTs cannot be used for payment or circulation, and no trading or speculation involved. And it's generally advised to distribute it for free if it is for marketing purpose or by lottery or at a very nominal price. Not to create any significant direct revenue, otherwise it may be directly connected to cryptocurrency or tokens that the regulator is quite sensitive for it. Further, any IP issues need to be cleared before doing marketing with any artwork for NFTs for sure, same as in any other part of the world. I guess that's it. That's all what I'm going to share today. Thank you.
Thank you so much. And just, we wanted to leave you with parting thoughts about, as many of the panelists have reminded each of us, NFTs may soon be regulated and controlled very differently than they are now. So we felt it was important to say to anyone who's advising clients looking to make a big investment in this technology, whether it's to build a platform or invest creatively in the space, that given the regulatory and legal uncertainty and the evolving technology, it's important to remain nimble and prepared to reevaluate any of these risks as this new technology unfolds and the legal world tries to catch up. So with that, I will say that the next 3 minutes can be dedicated to any questions from our audience, and thank you all for joining us. Anyone brave enough to put something in the Q&A? We had someone say 3 minutes might not be enough, which I think is funny. Well, we are all here to the extent that anyone, would like to speak to us. We're happy to speak to you about this. And I do agree, a lot of this can be overwhelming if you're new to the non-fungible token space. So yes, James said, can I unmute? Oh, look at this. Now we're getting some questions. James, feel free to unmute. Oh, he said I cannot. Can you put your question in the chat? So in the meantime, we had a question, given the uncertainty, especially around securities regulation, is there a practical approach to limit risk? And the answer is, again, just a disclaimer that I am not a securities lawyer, but I think drops that function as fun marketing projects and have nothing to do with a promise of don't function as an investment contract, have nothing to do with pooling assets with the promise of a return, are not something in which you give your money over to someone else in order to make a return, really help to move any NFT project away from securities risk. Now, of course, every project will have to be looked at on a case-by-case basis, but we are finding the securities risk most frequently arises when we have projects where it's really the promise of using NFTs as an investment vehicle. Now, that said, NBA Top Shot also got sued for securities risk with the theory that just the idea of having a marketplace that buys and sells these moments is in and of itself potentially risky from a securities perspective. So we'll just have to see where that lands. So we also saw how can we protect our agency partners from any responsibilities around proper disclosures with regards to NFTs. Obviously, this should be provided by the brand, but what if the brand is not properly informed? So, I represent a lot of agencies in my practice, and one of the things that I've been very sort of bullish on, not to use an NFT phrase, is making sure that the agency doesn't do what it normally would do, which is to be such an incredible partner to its client that it ends up taking on more risk in this space than it needs to. I think we need to be very clear, what is the client responsibility and what is something that the agency is willing to, to take on. And I think that it is very important that the client understands that most of this, it has to be managed as their risk, whether it's proper disclosures, whether it's opening a crypto wallet, all of that really needs to be a brand's own project. So we're actually out of time. I do want to make sure to be mindful of everyone's time, but if people do have questions, please do feel free to get in touch with any of us, and we really appreciate your time. And as Stacey said, the deck will be shared. So yeah, thank you for joining us, and we look forward to connecting with you again on the next gala event. Thank you so much.
Thank you.
Thank you.